Little.
Thank you, Mr Speaker. I rise to speak in this third reading of the Bail Amendment Bill. And, Mr Speaker, just start with some first principles when it comes to criminal justice. There are two things we look to the criminal justice system to do. The first is to convict and to deal effectively with the guilty, those who've committed crimes, those who have been found guilty after a consideration of the evidence and a decision made, whether by a judge or by a jury. But the second thing we require of the criminal justice system is to protect the innocent. Because the truth is that the enforcement authorities can get it wrong. And they can get it horribly wrong and catastrophically wrong. And over the years, over the generations, indeed over the centuries, the rules have been built up to ensure that those who face serious allegations of criminal wrongdoing from the state, with all the resources that the state brings to bear upon that process, that there are rules to consider the evidence and to ensure that those who are innocent, that those who are not guilty, are properly safeguarded and protected. Part of that process is the time between an offender or an alleged offender is charged and the time they are tried. And as other speakers have already noted, Phil Goff and also the Minister Judith Collins, and indeed the last speaker as well, noted that actually we do have delays in our criminal justice system in New Zealand at the moment. And we've had those delays for some time now. This is not new. And that has made the decision about how to manage an alleged offender in the meantime a very important one, because the longer the time between a person being charged and the time they get tried, the longer that period of time is, then that weighs against incarcerating them, because if they are subsequently found not guilty, then they themselves face or have experienced an injustice that we should not take lightly. And so the bail decision is a very important decision. But, and as my colleague Phil Goff has pointed out, what we have seen in more recent years is that some who have been released on bail, free to move about the community but under conditions, have offended, continued to offend on bail. And so the balance has had to be restruck to ensure that when judges are considering what to do with alleged offenders, particularly those who have a prior track record, and especially when that prior track record is are convictions for the same or similar offences, then judges are now more alert to the risk assessment needed to make a decision on whether bail should be granted. And that is a healthy response to growing community concern about that particular issue. And so, sir, this bill, I think, seeks to strike that balance. And I think, notwithstanding some ongoing reservations that we have, particularly about the treatment of young people, by and large, this bill gets the balance about right. For serious offences, and where there are alleged offenders who have previous convictions for serious offences, then it is no longer a matter for the police having to demonstrate why bail should be denied and why they should be incarcerated. It is for the defendant in the matter to demonstrate that they do not pose a risk to the community. And I think that is an acceptable trade-off to make in our criminal justice system, where a track record of convictions clearly elevates the risk that an alleged offender poses, and therefore it is a matter for the judge, I think, to take into account and to say, well, all right, you've had these convictions, you've offended again, clearly the risk is heightened, and so the presumption would be to detain you, but you have an opportunity to demonstrate to this court why you should not be detained and why you should be released on bail. So this legislation does not deny bail, at least does not automatically deny bail to alleged offenders, but it does heighten the hurdle, if you like, for them to jump in order to continue to enjoy their freedom until such time as they are tried on the charge that they face. It heightens the obstacle, if you like, for those on very serious offences and those on serious drug offences. And I have to say, Mr Speaker, in light of events over the last few years, that I don't find that objectionable, and at a time when public safety and community safety, particularly through with the management of offenders and those with a track record, that is an acceptable standard to legislate for. And it is for the same reason that I think it is going too far to say that just because you have been charged with an offence, even if you don't have any prior convictions, that should lead to a presumption that you should be detained over being granted bail. And I think that was the conundrum in the dreadful Tracy Marceau case, where a judge dealing with a young offender who had no previous conviction, facing a serious charge, one of kidnapping, and had no information about what subsequently became known about that offender's mental health, made a decision to release that offender on bail, with the tragic consequences that it had to the Marceau family. And I think, the reality is that this law would not change that situation in terms of the judge's discretion and what the judge has to do when dealing with that application for bail. And I think that highlights another very important point too, and that is that in the end, it is the judges sitting in court with the information provided by the police and the defendant who are in the best position to make judgments about the management of the offender or alleged offender, as the case may be. There are repeated calls to limit and reduce, in some cases eliminate, judges' discretion when it comes to these matters of the human frailty and humankind. And, Mr. Speaker, I just register my strong objection to that. We charge judges with a very difficult task, and I don't know of any judge who, when dealing with whether it's a bail application or sentencing and the possibility of incarcerating a person, that they do not take great care with that decision. Most of the applications for bail the judges deal with are on minor matters and do not need to be particularly taxing of a judge's time and intellectual effort. But in the very serious cases, judges do need to have the means and the time and the resources to pay very careful attention to the matters before them. And for that matter, I think anything more that can be done to assist judges and give them the means and the tools and the methods to undertake a proper risk assessment of an offender or an alleged offender appearing before the court, then that is all for the good. And that is the sort of thing that we should be encouraging when it comes to the effective administration of our criminal justice system. So, Mr. Speaker, notwithstanding the reservations that we've had from the outset, because of a pattern that we have seen over many years now of our law of just shifting that balance and while trying to secure public safety through the effective management of the guilty and those who act antisocially, we have to make sure that we don't also, in that process, capture the innocent and treat them unjustly. That is always the difficult balance that the criminal justice system has to deal with. One of the good things that this bill does is that it elevates to judges only to consider bail applications in cases of serious drug offences, and that is as it should be. I want to conclude by just simply commenting again on one of the matters that appeared in the Minister's supplementary order paper that was tabled only yesterday, and that is the issue of the management of electronic bail. And although the Minister gave an explanation today that she hasn't hitherto given, even after I requested an explanation from her office yesterday, that explanation still does not deal with the mechanics of how the Minister's discretion on who will be responsible for electronic bail is going to be exercised. All very well allowing it to be done by either the police or corrections or both of them, but how is a decision going to be made on who is best equipped to do it? The Minister says corrections is best equipped to do it. So why not give the job to corrections? They already monitor those who are sentenced to home detention and to sentences that carry electronic monitoring. Why not give them that job? Why provide in the law for either the police or corrections or both? We still haven't had an adequate explanation of the way in which that discretion by the Minister might be exercised and the grounds that the Minister might take into account on making that decision. Is it going to be done on a regional basis? Is it going to be done just simply saying, yes, both departments can do it and you sort it out amongst yourselves? So that remains an unsatisfactory element to this bill, Mr. Speaker, and no doubt this House will have to monitor very carefully its application and implementation. But notwithstanding that, Mr Speaker, as I've said, we will continue to support the bill.
Jan Logie.